Good day, my name is Anna Marie Millan, and I am presenting the highlights of the Republic Act 7942, also known as the Mining Act of 1995, and its current revised implementing rules and regulations, which is the DAO number 2010-21. It was March of the year 1995 when the late former President Fidel Ramos signed into law the RA 7942, also known as the Philippine Mining Act of 1985. This is for the purpose of reviving the mining industry and attract more foreign investment by defining the agreements for mineral exploitation and provide the requirements for acquiring mining rights. Here are the definitions of this. The state refers to the Republic of the Philippines. The onshore, contiguous zone, offshore, exclusive economic zone. Then there's private lands, public lands, ancestral lands, which is owned by the indigenous cultural communities, or the ICC. And talking about the indigenous people, or IPs, their rights are covered in the Republic Act number 8371, also known as the Indigenous Peoples' Rights Act of 1997, or IPRA. So the opening of ancestral lands for mining operations are covered under Section 16 of this Act. And opening of ancestral land won't be possible without the agreement, and when there's agreement, there are royalty payments involved that needs to be paid to the ICC, or the Indigenous Cultural Communities. Here are the following areas open to mining operations, as well as the areas close to mining operations. The areas close to mining operations are the following from A, B, all the way up to E, F. Mineral land is generally what is referred to when the land can be found containing minerals, not necessarily that these found minerals are economically enough to be mined for a profit. The contract area is the area covered under the MPSA or any other mineral agreements and financial technical assistance agreement, or FTAA. Inside the contract area, there are portions that are not used for mining purposes, but the rest are used for development, mining utilization, and sites for support facilities or in the immediate vicinity of the mining operations. These areas are called mining area. For the mineral resource, it could be large quantities or deposits of minerals, but are not very economically viable. Only some portions of it can be declared as mineral reserves or ore reserves, which are the ones with higher potential of being mined for a profit. Section 20, the exploration permit granted by the Bureau to the qualified person to allow him or the contractor to conduct exploration. And in addition, exploration permits last only for 2 years, and it shall be subjected to annual review. But it can also be renewed for every 2 years. The term used to refer to the holder of the exploration permit is the permittee. Then, force majeure means any acts or circumstances beyond the reasonable control of the contractor, such as the following. During the exploration stage, a feasibility study will be conducted to confirm or find out the economic viability of the project before acquiring MPSA issued by the Mines and Geosciences Bureau. Alongside this activity is a very long process of acquiring the environmental compliance certificate. Any project that has potential to propose environmental destruction has to conduct environmental impact assessment, wherein the possible hazards and risks that will be brought by the opening of the project will be identified, as well as the proper mitigating controls that has to be applied. This is then submitted in paper or document form called the Environmental Impact Statement, or EIS. The Bureau will go through their own processes of receiving, reviewing, verifying, and all of that before they will finally issue the environmental compliance certificate to the parties applying for it. The DEN, or what is referred to as the department, is headed by the secretary, which is also the representative of the president. Under the DEN are the line bureaus such as the MGB, or the Mines and Geosciences Bureau, and the EMB, or the Environmental Management Bureau. The function of MGB is that it is directly in charge. It ensures the compliance of mines with the Mining Act, administers and disposes mineral lands and mineral resources through the grant of exploration permits, or EPs, and or mineral agreements, or MAs, to duly qualified entities, while the EMB supervises the observance of applicable environmental laws. Qualified person refers to contractors that adhere to the legal requirements. After being qualified, this person can now apply for and acquire exploration permit. And if you're a holder of an exploration permit, the person will be referred to as permittee. This permittee is then able to enter into agreements with the government to mine on the government's behalf. This person will now be called the contractor. A contractor is different from a service contractor, because a contractor is someone who entered into agreement with the government, while the service contractors are employed by the contractor or the mining company to be of service to certain aspects of the company. The holder of exploration permit may apply for the following. He can apply for a mineral agreement or a financial or technical agreement, technical assistance agreement, or the FTAA. There are three modes of mineral agreements: the MPSA, which is the most common, or the mineral production sharing agreements, then the co-production sharing agreement, and joint venture sharing agreement. Mineral agreements can be converted into FTAA, and likewise FTAA can also be converted into mineral agreements, but with a lot of factors involved and has to be considered. Here are the delineation for the maximum contract area under the financial or technical assistance agreement, and on the right is the maximum areas for mineral agreement. Here are the definitions of each modes of mineral agreements. Then in Chapter 7, titled the Small Scale Mining Act, which is covered under a different law called the Republic Act number 7076. Chapter 8 is the quarry resources. A qualified person may apply for a quarry permit to the Provincial City Mining Regulatory Board, and this permit covers only 5 hectares at any one time, and its term is only for 5 years, but is renewable for like periods, but not to exceed a total term of 25 years. And in addition, no quarry permit shall be issued or granted on any area covered by a mineral agreement or financial or technical assistance agreement. Here are some other permits for specified commodities under the quarry category. Chapter 6, the transport, sale, and processing of minerals. No ore shall be transported without first acquiring ore transport permits that is issued by the mines and regional director, who has jurisdiction over the area where the ores were extracted. But in the case of mineral ores or minerals being transported from small-scale mining areas to the custom mills or processing plants, the Provincial Mining Regulatory Board or the PMRB concerned shall formulate their own policies to govern such transport of ores produced by small-scale mines. Without the ore transport permit, it shall be considered as evidence of illegal mining. But ore samples not exceeding 2 metric tons to be used exclusively for assay or pilot test purposes shall be exempted from such requirements. Then in section 54, the mineral trading registration, no person shall engage in the trading of mineral products without adhering to these conditions. Then section 55, the minerals processing permit, of course, no processing of minerals should take place without the mineral processing permit issued by the secretary. Then chapters 10, the development of mining community science and mining technology. And then chapter 11, safety and environmental protection. Here in section 64, mine lyrics specify that no person under 16 years of age shall be employed in any phase of mining operations, and no person under 18 years of age shall be employed in an underground mine. The mine inspection, power to issue orders, report of accidents. The person in charge of operations shall immediately report any incident or accident to the regional office where the operations are situated, because failure to report the incident or accident that occurred without justifiable reason will be a cause for imposition of the administrative sanction prescribed in the rules and regulations implemented in this act. Then section 17, environmental impact assessment or EIA, and then rehabilitation, section 7. Section 72, timber rights or the right to cut trees, and then water rights under section 3, rights to possess explosives, right, entry into private lands and concession areas. And then here in chapter 13, the settlement of conflicts. It shall be settled with the panel of arbitrators, which is composed of 3 members, 2 of whom must be members of the Philippine Bar in good standing, and 1 is a licensed mining engineer or a professional in a related field, and duly designated by the Secretary is recommended by the Mines and Geosciences Bureau Director. The panel shall have exclusive and original jurisdiction to hear and decide on the following, from A, B, C, up to D, and then section 78, appellate jurisdiction, Mines Adjudication Board, and then chapter 14, the government share, the government share in mineral production share agreement, the government share in other mineral agreements. Then the allocation of government share. Under chapter 15, the taxes and fees. We have the income taxes, taxes on mineral products. Mine waste and tailing fees. which the Secretary is authorized to increase the mine waste and tailing fees when public interest so requires or request upon the recommendation of the elder. Then the occupation fees. Also, the Secretary is authorized to increase the occupation fees provided herein within the public interest so requires upon the recommendation of the Bureau thereof. The manner of payment of fees. The allocation of occupation fees. Filing fees and other charges. Then Chapter 16 Incentives. Incentive for pollution control devices, income tax carry forward losses, income tax accelerated depreciation investment guarantee. Chapter 17 Ground for cancellation, revocation, and termination. Late or non-filing of requirements, violation of terms and conditions of permits or agreements, non-payment of taxes and fees, suspension or cancellation of tax incentive and credit, falsehood or omission of tax in this. Then Chapter 18 Organizational and Institutional Arrangements, from Staff Bureau to Line. And then Chapter 19 Penal Revision, the false statements, illegal experiment, theft of minerals, destruction of mining structures, mines are willful damage to a mine, illegal obstruction to permittees or contractor, violation of the terms and conditions of the environmental compliance certificate, illegal obstruction to government of other violation, fine. And then the final chapter, Chapter 20, Transitory and Miscellaneous Provisions. Non-impairment of existing mining quarrying rights. Recognition of valid and existing mining claims and lease quarry applications. Separability clause. Repealing and money clause. Activity clause.